as I already said, today's topic of discussion will be trademarks, and it is highly recommended that after this session, you have a look at our full document, full notes on trademarks, because in this session, we will only discuss some part of important laws and not for you to have a full understanding of trademark law and cases. You need to go to our website and have a look at our materials. However, we'll go through some very important legal provisions in this session. We'll start with what is a sign, the definition of a sign that can be subject to trademark. Article 3 of the Trademark Directive 2016, any signs with any particular words, personal names, designs, letters, numerals, colors, shapes of goods, or packaging of goods or sounds, all of which sit under the two conditions that they can be distinguished from other undertakings and are representative of the register in ways authorities and public can easily recognize its subject matter of the trademark. As you can see, a sign can be anything that is listed here: words, names, designs, letters. So most probably in a problem question, the first thing you would need to do is to define what is a sign, and then say which one of this list the subject matter that you are concerned with in the facts of the case should fall under. If it's a word, if it's a combination of word, then you can say that the subject matter of the trademark is a word which can be a sign under the Trademark Act. Trademark Directive 2016 is we have used Trademark Directive 2016 as a definition, but UK law should be used if you want to cite an authority in a problem question. The relevant legal authority for trademarks in the UK is Trademark Act 1994. Section 1 provides the definition, which is very similar to the directive. And very important that you need to consider here is that the sign has to be able to be distinguishable goods or services. So it has to be somehow a sign should be able to distinguish the goods or services that it represents in the eyes of the public as well as relevant authorities. Registered trademarks are different from unregistered trademarks. Trademark can be any brand. However, not all of them are registered trademarks. And if the brand is not a registered trademark, then it cannot have the protection under the Trademark Act 1994. So the first thing you need to watch out for is on the facts of the problem question is whether or not you are discussing a registered or unregistered trademark. A registered trademark is a property right obtained by the registration of the trademark. And you need to say that in a problem question and cite Section 2 of the Trademark Act 1994. No proceedings like to prevent or recover damages for the infringement of an unregistered trademark. If it's an unregistered trademark, infringement actions cannot be brought under Trademark Act 1994. However, a tort of passing off can still apply. So another cause of action can be launched if it's not a registered trademark. For a sign to be registered as a trademark, there are some limitations. It can, we call it absolute grounds for refusal of registration or relative grounds for refusal of registration. If any of these grounds apply, then the registration will be denied. Absolute grounds are the following. The following shall not be registered: signs which do not satisfy the requirements of Section 1, which we discussed earlier, has to be represented in the eyes of the public and relevant authorities as something clear, precise subject matter, distinguishable goods and goods or services. It consists of words, designs, letters, numerals, colors, and so on. So it has to comply with Section 1, and then it has to have a distinguishable character. It should not have devoid of any distinctive character. Trademarks which consist exclusively of signs or indications which may serve in trade to designate the kind, quality, quantity, intended purpose, value, geographical origin, the time of production of goods or of rendering of services or other characteristics of goods or services. And trademarks which consist exclusively of signs or indications which have become customary in the current language. So these are the exceptions. If the trademark falls under any of these exceptions, then it cannot be registered. So it has to have distinguishable character. It cannot simply be explaining the kind, quality, quantity, the purpose. Has to be something different that is not purely just the description of geographical origin or what the product is doing. And also it cannot be a sign or indication of something that has become a customary in the current language. So the words that we usually use every day will be harder to register as a trademark, because it's hard to show the distinctive character of the word, the everyday language. Section 3.2 also states that signs describing the functionality of the product should not be registrable. Section 3.3a, trademarks contrary to public policy and morality and trademark deceiving the public can also be not be able to register. So if any of these grounds apply on a problem question, you would first have to state that under this section, section 3, it cannot be registered, and then it should not be conclusive proof. You should also go into a deeper discussion of if there are any applicable cases on decided on this area of law on the absolute grounds of refusal, and if the facts are similar, if the facts are similar to the facts that you have been given in the problem question, that you need to apply the similar facts as well as generally the principles that has come out from a case law under section 3. So how it has been interpreted in the case law. Section 3.4, use of trademark is illegal if in any case if the trademark was used would be illegal, then it cannot be registered. There are also relative grounds for refusal. Relative grounds are different, so it's about if the trademark in question is related to any of the earlier trademarks. It's all about protections being on the trademark register efforts to a mark holder and how they might be able to bring infringement proceedings against another. So if there is already a registered trademark for a mark that in a problem question your client wants to register, then you can discuss relative grounds for refusal and say that if the trademark is already registered, then and if the mark that your client is trying to register relates to the earlier trademark, then relative grounds for refusal can apply. Discuss section 5 is the relevant provision from the statute for relative grounds for refusal. A trademark shall not be registered if it is identical with an earlier trademark and the goods or services for which the trademark is applied for or is registered with are identical. So not only the sign has to be identical, but also the goods or services. If someone is trying to register a trademark that is in another industry, that would be fine. So it has to be both. It has to be one, identical with an earlier trademark, and two, it has to be identical in the same and selling the same goods or services. Because of its identity with or similarity to the earlier trademark and the identity or similarity of the goods or services covered by the trademark, there exists a likelihood of confusion. This is the second point of discussion in a problem question. You need to discuss whether or not, given the circumstances, the public would confuse the trademarks with each other. If similar trademarks are registered and if they are in similar industries, what is the likelihood of public confusing them with each other? If the likelihood is high, maybe Article 5 will apply and a trademark will not be registered. Also, infringement is an important area of law. You need to know about trademarks, because a problem question can be either about registration of trademark or also about infringement. Usually it's either of the two, but it can be both in the same problem question. A person infringes a registered trademark if he uses in the course of trade a sign which is identical with the trademark in relation to goods or services which are identical with those for which it is registered. So the key word here that you need to discuss in a problem question is use of a registered trademark in the course of trade. So you need to have a look at the facts of the problem question and see which part of the problem question demonstrates that the person has used a registered trademark in the course of the trade. It can be something like if they used the name of the registered trademark in marketing campaigns, or if they have sold their products with the name of another registered trademark. That can be also use of the trademark in the course of trade. And the threshold is quite low. If you have a look at the relevant cases, you will see that any use of the registered trademark usually can amount to, can satisfy this requirement. Therefore, if you need to identify which part of the problem question shows that the defendant has used the trademark in the course of trade. A person infringes a registered trademark if the sign is identical with the trademark, or the sign is similar to the trademark and used in relation to goods or services identical with or similar to those of the trademark is registered. Therefore, if it's identical, then it's easier to show the infringement. But if it's only similar, then you need to go through the similar cases and have a look if the similarity is enough to satisfy the infringement requirements. There are defenses to infringement. In the problem question, once you show that the infringement has occurred, then you need to discuss whether or not there are any defenses. And after the defenses, you need to discuss remedies. What are the remedies for trademark infringement? The defenses, you need to have a look at section 11 and 12 of the Trademark Act, 1994. Defenses can be use of indications about kind, quality, geographical origin, or other characteristics of the goods or services. So everyday language to describe what the product is like, a characteristic of the product, that can be a defense. So nowadays, more and more people are using an everyday language to describe their products. It is possible that the same words are used by registered trademarks in similar industry, but it's a defense. The infringement proceedings cannot succeed in this case because it's an everyday language used to describe the characteristic of the goods or services. However, in the particular problem question that you have in trademarks, it is important that you have a look at the decided cases on section 11 defenses and have a look if there are any similar facts of the case you can identify and apply that case to your problem question. Another defense that you can mention is indication of an intended purpose of the goods. So if someone is simply indicating the purpose of what the product is doing, the product's purpose, that can also be a defense. The use by a person of their name or address. If someone is using their own name and it coincides with another person's name who is already selling products with a registered trademark, that can also be a defense. Infringement proceedings cannot be brought in those kind of cases. So what can be a problem question can have the following issues. A trademark problem question can be about registration of a trademark. So it can ask you on the given facts if the sign that has been described could be registered. Obviously, you won't have all the details, and you need to make assumptions. You need to say all possible outcomes that there can be if this sign that has been described to you were to register as a trademark. So in what kind of cases do you think that the court would say that, yes, this should be a trademark, and what kind of cases the court would say that it shouldn't be a trademark? And obviously absolute and relative grounds of refusal should be discussed here in detail to give the examiner a full overview of the relevant laws and show that you understand what are the grounds on which a trademark registration can be refused. And another area of law where that problem question can be about is infringement. Usually it's either of the two, but it could be both of them together. Infringement is when you are given facts of the case which shows a potential trademark infringement, and you need to discuss to what extent it can be an infringement. You obviously apply Section 10. We'll go through that in more detail. So problem question about trademark registration. You should start with what is a sign, like define what is a sign under Trademark Act. What kind of signs can be registered as a trademark, which is Section 1 of the Trademark Act. Also apply relevant case law. Absolute and relative grounds of refusal. Section 5 is relative grounds of refusal, whichever one applies. And make sure that you not only mention the relevant statutes, but also mention the cases that are applicable on the facts. About the infringement problem question, you need to first discuss if Section 10 of the Trademark Act applies, and if the fact that has been described to you could constitute an infringement. There is no right answer in law, but you need to give assumptions of in what kind of case court could, on what basis the court could say that yes, this is an infringement, and on what basis the court could say that it's not an infringement. And you make those assumptions always based on the relevant statutes and based on the relevant cases. Then you need to discuss if there are any defenses under Section 11, if it's use of someone's name, someone's address, if it's just describing the characteristic of the good, it's only indicating the purpose of the good that is being sold. After defenses, you need to discuss the remedies. What are the remedies? What can happen after the trademark infringement? Remedies can be different. It can be injunction, it can be damages. So you need to discuss which one would be most applicable and answer the problem question asked. The suggested reading are our simple notes, example essays, kits, summaries, tutorial videos, quizzes, and flashcards that we have on IP law. We have both UK and international IP law that you can have a look. Now I'd like to discuss a little bit about how we can help you. We are a group team of graduates, a team of law graduates who have all achieved Height 1 and first class grades in our relative respective law degrees. And we have created simple study resources focusing on students to get high grades. If the resources are not enough, you are highly encouraged to have a look at our tutoring services, which is a one-to-one help for students to help you get high grades on specific questions that you may have. We have already helped thousands of law students to get high grades. Our regular students usually get a first class, but that is most likely when students get both the subscription and the tutoring sessions together and regularly study with our platform. We would like you to be our next student to get high grades. Join SimpleStudying now. Thank you for your attention.